petitions against the Waqf Amendment Act 2025. So this is basically, filed by multiple people, and this was expected also because there was a lot of discontentment when this law was passed. Especially the opposition parties, they were not in favor of this law being passed. And the lawyers who are representing these petitioners are from the opposition parties, we will get to know. So this was quite, I would say, expected. Background: on May 20, 2025, Supreme Court of India heard a group of petitions challenging the Waqf Amendment Act 2025, which became a law on April 8, 2025. The petitioner said that the new law is a form of slow takeover of Waqf properties and hurts the rights of India's Muslim community, the largest religious minority. Now, why they are saying this? Slow takeover, and it hurts the rights of India's Muslim community. All these we will see in this topic. So, constitution presumption versus violation. So, just to make you guys clear that any law being passed by the Parliament of India, if it is against the ethos of the Constitution or if it is against any provision of the Constitution, then that law is termed to be unconstitutional. And that can be struck down by the judiciary. Judiciary has such powers. Judiciary means the courts. Now, the petitioners who have filed a petition in the Supreme Court with respect to the Waqf Amendment Act, they are calling various provisions of the amended Waqf Act as unconstitutional, as unlawful, and they are demanding for them to be struck down. But while opening the remarks, Supreme Court noted that a law made by the Parliament is usually assumed to be legal and constitutional. Because before making the law, passing the law, the government also knows that if it is unconstitutional, the judiciary will strike it down. To make sure that these are not violating any constitutional principles, not violating any legal principles. This is what is kept in mind by the lawmakers also. That is the government. So, Supreme Court noted that law made by the Parliament is usually assumed to be legal and constitutional. Senior advocate Kapil Sibal, he belongs to the Congress party, for the petitioners said, this assumption can be challenged if there is an obvious violation of rights. If there is an obvious violation of rights, this assumption can be challenged. The court can temporarily stop the law if it may cause serious harm to people's rights. This is also another option which he said. You don't discard that provision, but you temporarily stop that law and you assess. Now, the main concerns raised by the petitioners. The multiple concerns have been raised and we will pick up these concerns one by one for discussion. The first concern is violation of minority rights. So, the law goes against Article 25, that is freedom of religion, and Article 26, right to manage religious affairs. The right to manage religious affairs has been given to the religious communities as per Article 26, and freedom of religion has been given to the individuals that you can freely practice, profess and propagate any religion. Now, it allows the government to take over Waqf land without any compensation, which is normally given in other land acquisition cases. So here, right to equality is also violated. So, they are saying that various articles of the Constitution are being violated, and these are the rights of the minorities. Now, there is section 3C, the dispute clause. The section allows any person to raise a dispute over a Waqf land. Earlier, there was this provision that if the Waqf has decided that this particular land belonged to Waqf anytime in the past, it should be Waqf land, then they can claim over that. That was the provision, and that provision has been removed by the government. Now, section 3C, any person to raise a dispute over Waqf land is allowed. The dispute is looked into by the government official with no fixed timeline or clear rules. This government official is the district magistrate or the collector. Even a small dispute can stop the entire Waqf property from being used. For example, if someone has raised that this is not a Waqf property, but it has been working as a Waqf. The Waqf, let me tell you, guys who did not attend that session about the Waqf Amendment Act. So Waqf is any property which is donated by the Muslims for the welfare of the religion, that is Islam. It can be used as a mosque, it can be used as an educational institution, it can be used as a hospital, it can be used as a playground, anything. There had been multiple amendments in that over the years, and the latest one was 2013, where it was declared that any individual, not only Muslims, but any individual can donate his or her property as Waqf. And if the Waqf board claims over any property which is not declared as a Waqf, that this is a Waqf, then that property also has to be given to Waqf. That was called as Waqf by law. So they had taken claims over multiple properties and had, exploited many people, made them devoid of the rights. And all those corrections have been made now. And, again, there is a problem with many people that why these amendments are there. Now, even a small dispute can stop the entire Waqf property from being used. For example, schools, hospitals, burial places, community centers, and such like. If it gets disputed, if someone files a dispute, then it can be prohibited from being used. Now, during the dispute, the government can also demolish the property, give it to third parties, and declare it as non-Waqf. So this is the problem the petitioners are highlighting, that it should not happen this way because it is taking away the rights of the minority community, that is Muslims. Section 3D, the heritage sites. If a Waqf property is declared a protected monument under Ancient Monuments Preservation Act 1904 or Archaeological Sites and Remains Act 1958, it loses its Waqf status. Now, petitioners said that these laws are meant for preserving buildings, not for removing religious ownership. Why are you removing religious ownership? Protect them and keep the religious ownership also intact. Many religious places are both historical and religious, so both roles can exist together. This is what the petitioners are saying, and it is a genuine demand, I feel. Non-Muslims in Waqf boards. According to this amendment now, non-Muslims will be allowed to be members of the Waqf boards. There are state Waqf boards, and there is this, National Waqf Board, which are aimed at managing the Waqf properties. State Waqf boards are the main because they are at the ground level and they are instrumental in managing the Waqf properties. Now, earlier only Muslim members were allowed, but now non-Muslim members are also allowed. So this is what the petitioners are saying, that this weakens Muslim control over their own religious endowments. Other religions like Hindus and Sikhs don't allow outsiders to manage temples or gurudwaras. Why? Here, they should be allowed. But Hindus, the gurudwaras and temples are religious bodies. Waqf can be a non-religious property as well. So, this is there. Then section 3E, scheduled tribes. This section says that land owned by STs under 5th or 6th schedule of the constitution cannot be declared as Waqf property. Petitioners called this unfair and biased against Muslims. So, on one side we have to protect the interest of the STs. 5th schedule areas are there present in the 10 states of the country where the tribal welfare has to be ensured. 6th schedule areas are there present in 4 states of the country, Assam, Tripura, Meghalaya, Mizoram, where there is a tribal council which makes laws for the region comprising of the tribals. It gives them considerable amount of autonomy. So this, right ki bhai, if any, land is there in a schedule 5 or schedule 6 area that cannot be diverted for Waqf, this has been challenged by the petitioners and saying that you are violating the right of the Muslims. We should be allowed to divert such land, or we should be allowed to make such land as Waqf. Now, section 3R, 5-year proof of being Muslim. This section says, now in the 2013 Act, it was declared that any person can donate his or her property as Waqf. Now that clause was removed. Only a Muslim who is practicing Islam for 5 years can donate a property as Waqf. So the section says a person can only create a Waqf if they prove they have followed Islam for at least 5 years. Lawyers said this is unreasonable. It intrudes into personal faith. Article 25 being violated here. Violates Article 14 also, right to equality. They asked what proves someone is Muslim? Prayer, dress, or abstaining from alcohol. Then effect of old and unregistered Waqf. Around 50% of 8 lakh Waqf properties in the country are unregistered, passed down through tradition and use from one generation to the other, and like this. Like for example, someone donated a property as Waqf and a mosque was built over there. So Mullah ji came. Then, the Maulvi or Mullah ji passed away. So his future generations took over. They are managing that. They are managing that mosque. And that property is not registered with the Waqf board because that property was donated, and that Mullah ji has now passed away or Maulvi ji has passed away. It becomes important for informing the state Waqf board and all that they have passed away, and we are now carrying on the legacy, the future generations. So most of these properties become unregistered properties, and there is a provision that old and unregistered Waqf, they will be unrecognized. So under the new law, these unregistered Waqfs cannot go to court also. These include centuries old religious and charity properties with no formal documents. So if in case of any petition or something like that, or any dispute over them, they cannot go to courts. So this is what the petitioners are saying. Now constitutional articles involved in it: Article 14, right to equality. Different rules for Muslims, STs. Here, right to equality comes into picture. Article 25, freedom of religion. It stops religious practices, like stops from donating properties and all. So this is there. Article 26, right to manage religious institutions. Government control of Waqf. This is being questioned, that government is intruding into the religious, I would say, activities. And right to go to court. Unregistered Waqf can't file cases. Article 32 is being violated over there. These are the fundamental rights which are being violated as per the petitioners. Government's data on Waqf property disputed. The government said there was a 116% increase in Waqf properties from 2013 to 2024 using data from the VAMC portal. So many increase in Waqf properties. Did so many people actually donate properties? The petitioners replied that this rise is due to better registration, not actual new properties. It should not be used to justify stronger control or label it as misuse. This is what the petitioners are saying, that this rise which you are seeing is due to better registration. Next is impact on secularism. First point here is, senior advocate Rajiv Dhawan said that religious belief, practices and property are all parts of religious freedom. And all these are being impacted. Actually, secularism in Indian context is, you need to understand the meaning of secularism first of all. This term was coined in the aftermath of French Revolution, 18th century. People in France were fed up with the king, the policies of the king, and continuous, I would say, interference of religion in the state affairs, in the king's affairs, and such like. Like at that time, superstitions dominated, things like these were there. So let's suppose the priest came to the king and said, "Hey king, I want that piece of land. If you don't give me that piece of land, you will lose the next war." And the king was like, okay, he evacuated the common people from there and he gave that piece of land to the priest. Excessive interference of religion in the state affairs was this. And the end sufferers were people. And vice versa was also true. State also interfered in religious affairs at times. So people, when they went for French Revolution, that was a successful revolution. People demanded that there will be secularism. What does secularism mean? It simply means separation of state and religion. State and religion should be mutually exclusive. State means the government, the king at that time. Now, India is a secular country, no doubt about this fact. But Indian concept of secularism is a bit different from this Western concept of secularism. Although at the core of Indian secularism also this essence is there. Like, what does the Indian secularism mean? Indian secularism simply means the state will have no official religion. No official religion of the state or the government. We do not say that we are a Hindu government. We say that we are government of India. Like Pakistan says, Islamic Republic of Pakistan. Clearly highlighting that the official religion of that country is Islam. Or for that matter, Iran says that we are a Shia theocratic republic. They're openly claiming that we are a Shia country and our official religion is Shia Islam. We practice that. But we are not claiming any religion to be an official religion. We say that we are the Federal Republic of India or we are the government of India. So state cannot have any official religion. So in this particular aspect, we can see that the state has separated itself from religion. That is why I was saying that this philosophy is there in India's secularism, but India's secularism is more than just this philosophy. This is the first component. Second component is that it is the duty of the state to protect all religions which are existing in our country. The word is protect. It is not promote. It is protect. So it is the duty of the state to protect all the religions existing in our country. And the third is there is freedom of religion. This is there. So this is the Indian concept of secularism. It is considered as positive concept of secularism also, and this is called as the negative concept of secularism. We are talking about separating over here in the negative concept. In the positive concept, we are talking about protecting all the religions. And in this Waqf law, that is why, the secular features are being questioned. The senior advocate Rajiv Dhawan said the religious belief, practices and property are all parts of religious freedom, which are being taken away by these amendments. Taking away these rights can weaken India's secular system because freedom of religion, the third aspect, was there as part of India's secularism, and harm minority faiths. The law may also affect the Places of Worship Act 1991, which protects the status of religious places because multiple Waqf properties are mosques. So this is what you need to understand and know about it.